not even news.
So after this one, I don't see any more events on the calendar.
Because they didn't send any out.
Yeah, I know.
Three not here, they send us a month to wait. As a matter of fact, the one for
But
tomorrow.
there's 2 in March on the website.
Already? The one for tomorrow? The one for tomorrow came in this morning, like around 9 o'clock. We did be here at 3 o'clock. Luckily, we didn't have any, I didn't have anything planned for 3 o'clock, so I could have gotten here at 3 o'clock. I was like, really?
Yeah, Shruti.
I'm not shooting for that though. She would be on top of that, man.
Yeah.
She was really good like that. Oh well. Hope she's having fun where she is. Doing what she wanted to do.
I know these people around here, they don't care, man.
Yeah. The only one to eat on this album was wrong.
They just live in the dream. Just sitting around getting paid. When something goes wrong, everybody's like, what happened? What happened? What happened?
Wanna freak out.
Check 1, 2, test, test, 1, 2.
NYU, Washington, D.C., and I'm happy to welcome you to the Abramson Family Auditorium for the second official program in our Black History Month series, The Loving Story. A special thank you to the National Endowment for the Humanities for partnering with us in this series. A little bit of background. As the nation marked historic anniversaries this past year of the Emancipation Proclamation and the March on Washington, Created Equal brings together nationally acclaimed documentary films on the long civil rights movement. As the Created Equal films have been viewed, they have begun a conversation. People of all ages, different races, and walks of life have been moved to continue talking about the themes raised by the films. Many are inspired, some are outraged. Often viewers are left pondering what it takes to achieve real change in a democracy, what can be learned from the struggles of those who went before us, and how to connect their own lives and experiences to this powerful history of heroism and struggle. Tonight we will screen The Loving Story, and we welcome Bob Bauer and Phil Hirschkopf, who will lead us in a discussion about the landmark Supreme Court cases that have affected the way the United States has evolved on issues relating to race, love, and gender. In Bob Bauer's 30 years of practice, he has provided counseling and representation on matters involving regulation of political activity before the courts and administrative agencies of national party committees, candidates, political committees, individuals, federal office holders, corporations, and trade associations and tax-exempt groups. Bob served as White House counsel to President Obama and returned to the private practice in June of 2011. In 2013, the president named him to be the co-chair of the Presidential Commission on Election Administration. Bob was general counsel to Obama for America, the president's campaign organization, in 2008 and 2012, and he is general counsel to the Democratic National Committee. He has also served as co-counsel to the New Hampshire State Senate in the trial of Chief Justice David Brock, general counsel to Bill Bradley for President Committee, and counsel to the Democratic leader in the trial of President William Jefferson Clinton. Philip Hirschkopf is a constitutional rights attorney who has won numerous landmark cases in the area of civil rights, women's rights, teachers' rights, prisoners' rights, and animal rights, including the case of Loving versus Virginia. He is a founder of the ACLU of Virginia, the Law Student Civil Rights Research Council, and the ACLU National Prison Project. Served on the ACL National Board for 20 years and has been chief counsel for the People for the Ethical Treatment of Animals since it began. He is an ex-Green Beret paratrooper and father of 3. As a young lawyer just 2 years out of Georgetown University Law School, he took on the landmark case Loving versus Virginia as a volunteer lawyer for the National Capital Area Office of the ACLU. Philip Hirschkopf and Bernard Cohen represented the couple in losing appeals on charges in district and appellate courts, and after facing opposition at the state level, seized the opportunity to take the case to the Supreme Court. Despite never having argued in front of the Supreme Court, his compelling arguments and tireless efforts led to victory. In 1967, the justices struck down Virginia's ban on interracial marriage. This U.S. Supreme Court ruled unanimously in favor of the Lovings on June 12, 1967. This precedent-setting decision resulted in 16 states being ordered to overturn their bans on interracial marriage. Please welcome our guests. Thank you.
Shall I start? I guess I get to start. I can hear an echo myself. But, I did some notes, and I'll look at them sporadically. And doing the notes, it occurred to me that it was just 50 years ago this month that I took the bar. It was 50 years ago, half a century ago, that I got in a Loving case. I was actually 2 months out of law school when I got in a Loving case. I was 2 years out of law school when I argued in the U.S. Supreme Court. And I appreciate the kind remarks. Loving is a unique case. It's one of the great constitutional cases. But I can't claim any great skills in our winning of the Loving case or great arguments, as I'll get to in a few minutes. The ACO actually had picked someone else out to argue the case, a very renowned lawyer in New York. He probably would have made a much better argument. And Loving is a case that had reached its time. It wasn't a planned case like Brown v. Board of Education or other cases that someone sat down in advance and says, how do we attack these statutes? Let's design an attack. So to understand Loving, you have to have a historical perspective. The miscegenation laws, the mixed marriage law, laws against mixed marriages between the races, basically go back to the 1600s. The Virginia law went back to the early 1600s. And the real genesis of these laws is the early 1900s in this country. What was happening then, we had the Yellow Peril on the West Coast as Oriental people started coming in for railroad work. We had the Irish discrimination in New England as Irish people came in to avoid famine and all in their country. You had the terrible treatment of Mormons and Catholics in the Midwest and Catholics along the East Coast. We had anti-sedition laws. We just come out of the First World War, and more than anything else, we had a very widespread Ku Klux Klan across the South. And in that background, a number of states, over 30 states, enacted very tough laws about intermingling of the races. Why that fear then is just what was happening in the country. The unionism at that time produced scab movements, the treatment of the people who came back, the soldiers from the First World War, by our own government at that time. And through the 30s and 40s were difficult times. In the 40s, we went into the Second World War, and you start seeing some mingling of the races, particularly as with contact with foreign people. One of the great things that opened up the knowledge of this whole area is a study by Gunnar Myrdal, a very great man. Actually came to the United States to teach after a while. He was a Swedish lawyer, actually. And he did a study about what was happening in the United States with the Negro people. The American Dilemma, it was called, the Negro people. And he said the worst fear that the country had was intermingling of black men and white women, Negro men then and white women. That was the worst fear. Loving, of course, is a white man and an African-American woman, but, and Mildred Loving was part Indian also, because the laws are so absurd in Virginia. Not only one drop of one kind of blood made you a different race, but if you had 1/16 of a certain kind of Pocahontas Indian tribe blood, you were then white, or less than 1/16 of that, because there was such cross-pollination going on in that area of Virginia. They kidded about, it was the area known for blue-eyed black people. And it's that kind of idiocy, that kind of language, that makes you understand the idiocy of these laws. But that was the background of it. And as we got to the period where we got out of the 50s, into the 50s, things were still hard in the country and racial, as we know. That 1954, we saw Brown v. Board of Education. That was a planned attack to change the treatment of the races. We start seeing freedom riders. We start seeing a lot of things happen. In 1958, two young people in Caroline County, Virginia, Mildred Loving and Richard Perry, her husband, they went off to Washington, D.C. to get married. The law then in Virginia was a felony to get married in Virginia. Well, they couldn't get married in Virginia. It was a felony to leave the state to get married. They could have a common law marriage then, but it wouldn't have been recognized. And when they returned, no one knows what happened. One of the flaws in our handling of the case is never was an adequate investigation made. And one night, 2 months after they got married, about 2, 3 in the morning, the lights went on, and a lot of spotlights in their faces, and the sheriff arrested them, took them off. Richard was released on bond shortly after that. She was held another 10 days on bond on a condition that they not be together. A year later, they were both convicted and sentenced to leave the state of Virginia, not return together at any time. It was a sentence of banishment, which is illegal, not recognized. There are cases against banishment in Virginia and across the country. And so you'll see in the film, they moved to D.C. Understand what's happening in Virginia then, because it also affects why this case went where it did. In the same year they got married, probably the worst period of Virginia history was the hanging of the Martinsville Seven, something very few people know about. But 7 young men were hung in a 2 to 3 day period for the rape of a white woman. It was the first time anyone was ever executed for rape in Virginia. They were hung solely because of their race. It had really nothing to do with the crime. Rape is not an admirable crime by any stretch of the imagination, but it didn't have the other features that add the death penalty. The woman wasn't brutalized. She knew a couple of the kids. She was immediately released. They didn't try to kill her. They were just some drunk young guys who forced themselves on her, and they should have been punished adequately for it. It produced an international movement. You'll see Governor Lindsay Almond quoted on the screen in this movie about the Loving case, but Governor Lindsay Almond was the one who refused to commute their sentences. And that's what was going on in Virginia. And in the face of that, it took a lot of courage for the Lovings to go defy this law and get married. But they never thought they're going to get prosecuted. They never thought anyone would care. There were lots of mixed couples across that area of Virginia. This is east of Richmond. And so they returned, and they were prosecuted, and they moved to D.C. They had 3 children up there. And in the District of Columbia, they hated it. They were used to the country living. You'll see some wonderful old footage that was able to be taken back then. They missed their family. One child got hurt in a car accident. And so they moved back to Virginia. They were arrested. They were told, don't do it again. They left. They managed to spend a couple years. Then in 1963, 62 actually, they went down to King and Queen counties, a neighboring county, Caroline County, and they secretly took up residence there, although they would go back to D.C. from time to time. And then the real history of Loving comes out about us. Remember in 63, and well, many of you won't remember 63, but from your knowledge of history, what was going on about us, there was the March on Washington that year. And there was a lot of publicity about it. And that was a year in the civil rights movement. A few of us will forget who were there, and a few who read about it will forget, because it started with the March on Washington, and there was the Equal Pay Act, which included women. And President Kennedy announced he was going to have an Equal Accommodations Act, which upset the hell out of the racists. And then 4 young girls in, I think, October, September that year, were killed at a church in Birmingham. And then a president was assassinated in November. It was in that milieu, although the letter written by Mildred Loving was before some of these events. In that milieu, she wrote to the ACLU and asked if she could be helped. There was no ACLU in Virginia. She wrote to Bobby Kennedy first. He referred to the National ACLU. They referred to the National Capital Area ACLU. And a young lawyer named Bernie Cohen was practicing in Alexandria, Virginia. He was 2 years out of law school. He'd worked for the Labor Department. Bernie had absolutely no background in criminal law, in federal law, in constitutional law, or appellate law. But he said he'd look into it. And the focus then was these 2 people just to help them out based on the sentence more than anything else. The Supreme Court had denied review in another miscegenation case that had just come out about 3 or 4 years before that from Norfolk. It was actually a Eurasian male and a white woman. But Eurasians were classified as black then, and I say Eurasians because there's a funny story about South Africa where the Chinese were considered black people and the Japanese were black people, but the Japanese were very commercially involved in the country, so they would change to white people, but then they couldn't tell the difference between them, so they became black people again. And that's the idiocy of the laws, which later, I'm not tell you a story, but is very germane to what our major legal decision we had to make in the U.S. Supreme Court when it went up. And so Bernie agreed to look into the case. He wrote a couple letters, one to the clerk of court, one to a man named Beasley, who was the defense counsel down there. They told him to get lost, basically. He got a couple letters from lawyers here in D.C. saying that where there's something like banishment, the court retains jurisdiction over the sentencing, and so you have a linchpin to get in there still standing. before the court. It's like an injunction that's ongoing, the court keeps control over. And so Bernie filed a 2-page petition. It had no law, it had no memorandum with it, it just wasn't his experience, to set aside the sentence. And it sat for a year, well, for 8, 9 months. And then 1964 came along. In 1964, we had the Equal Accommodations Act. We had the 3 boys killed in Philadelphia, Mississippi. We had the Justice Department going down and meeting people at the schoolhouse steps, Governor Faubus and the governor of Mississippi and the governor of Alabama. And Mildred, just 4 days after the Equal Accommodations Act was passed by the United States Congress, signed by the president, she wrote again to Bernie and said, "Remember me, I'm Mildred Loving. We've just about given up hope." Bernie didn't know what to do, so he went to see his con law professor at Georgetown. I had just graduated the month before that. I was visiting with Chet, and Chet Antio, a wonderful constitutional law professor. He's helped me with a case I filed in Newberry, North Carolina. I had been in Mississippi that summer, and I was going back and forth there, and had been in Danville, Virginia the summer before when there were mass beatings down there. And so I was sitting talking to Chet, and Bernie came in, and he talked to the law professor, and he introduced us. We walked across the street to the juvenile court over there on East Street, and he told me what he did, and I said, "Well, you got a problem, because if they set aside the sentence, they can re-sentence her, and you may never get an appeal out of it, and they can give her 5 years, her and him, 5 years in the penitentiary." I flew that night back to New York, the next day to Mississippi, and on a plane to Mississippi, I drafted up a lawsuit on a yellow pad I had and sent it to Bernie. I was going to go back to New York to practice law. I was educated in New York, although I went to Georgetown Law School. I was in night school. I'd worked in the U.S. Patent Office. I never thought I'd be a civil rights lawyer. And so I sent this thing to Bernie, and in a couple weeks, he offered me a job in his firm. I went down, looked through the file, and decided I would do that. I wanted to stay in Virginia and pursue civil rights law as I tried to make a living in plain civil law. And so we filed the lawsuit. We were lucky we had a great judge. We asked for a 3-judge federal court because in those days you could get a 3-judge court in substantive constitutional questions. And we got John D. Butzner, who was famous for the Trailways case, a number of other civil rights cases out of Richmond. And that court, after one argument before it, decided that if the state court didn't deal with this problem, then the federal court would. But because of the two systems getting along, the law is that the federal court would defer to the state court in questions involving constitutionality of state laws. And then the state court came down with a decision that you'll hear read there of some idiocy that God created the people in separate continents, and but for our interference, that's how it would remain. The Virginia Supreme Court affirmed that crazy opinion, but the Virginia Supreme Court did what I always feared. They remanded the case for resentencing. If they were resentenced, they could hardly raise the constitutional issues because they'd waived the constitutional issues by pleading guilty, which is the advantage of that federal lawsuit I'd filed. They then discovered, right after we filed the federal lawsuit, that the Lovings were living in Virginia. It was a huge shortcoming in the representation of their lawyers, although the film treats it much differently, because that could have screwed up the whole case. If they were sentenced for violating the order, we hardly could challenge that. Martin Luther King got sentenced for violating an illegal injunction, and he served the time because the injunction is binding until some court reverses it. They were under a binding order of a court. And so we faced jeopardy in that. We took it to Judge Butzner, and the state agreed they wouldn't prosecute the Lovings. So then once the Virginia Supreme Court got it, and we appealed the circuit court decision, they didn't take up the standing issue of whether they'd waived their constitutional rights or not. And we went on to the U.S. Supreme Court. As he said, I'd never been to the U.S. Supreme Court to argue a case. I'd been there to hear some cases. I'd had the privilege of arguing a few cases by then the Fourth Circuit and one in the Fifth Circuit. Went to the ACLU. They didn't want me to argue at all. They wanted Bill Zabel, who's just a wonderful lawyer out of New York, and he wrote the final brief, Bill. But we talked about it, and they said, no, you can argue, but Bernie Cohen can't argue. He had no experience arguing in appellate court. I felt strongly, and you'll see this in the film, he was co-counsel, and I really felt he could do it. I had argued in the Virginia Supreme Court, and I had argued in the U.S. District Court, and Bernie did make an exceptionally good argument in the United States Supreme Court. Going to the Supreme Court, we had to decide how to approach it. There were two areas of thought. One was to contest the due process issues, as I've said before. What kind of procedure is there in this? Just thinking, how do you qualify one drop of Negro blood or one drop of some other kind of blood? And all the laws, they were ridiculous, and you try and apply them to rational life. I wanted to take on the equal protection argument. I wanted to go and say this is a class-based lawsuit, and statutes like that should not be permitted. We had a big division among the lawyers. Fortunately, I won out, and so I got to make the lead argument on equal protection in the U.S. Supreme Court. When the Supreme Court decided it, they decided on two bases. One, that where a statute is based on race, the burden shifts to the state to show a compelling state interest. And that's very important to what's going on, as Bob will address, is how it applies to the present fight we're having about same-sex marriages. Because many of the parallels are very strong between the Loving situation, the miscegenation laws, and how they apply now to the same-sex laws. And the second thing they decided, which the case is more known for, is that there's a constitutional protection to a right of marriage. Marriage is not mentioned anywhere in the U.S. Constitution, but there are certain inalienable rights, certain fundamental rights we have in society. And so, in 1967, I got to read that opinion. I got to stand on a Supreme Court steps, have my picture taken with my father. Pictures that sat on the only picture that was on my desk for almost 50 years, 47 years. And that's basically the story of the Loving case. It's not a case where we really did anything particularly brilliant. It's a case that had reached its time. And based on everything that was happening about it, it was too late. But remember, that's what the law is. I know a number of you are law students, that's why I'm treating it like that. It was only 3 years before that they decided Gideon v. Wainwright, a case that for the first time in 200 years, that you had a right to counsel in a felony case. Interesting enough, as I recall, Abe Fortas, who argued Gideon, was on the Supreme Court when we argued Loving. And that's the story of it. And how it got here, and they view Loving is now being quoted widely in the arguments on same-sex marriage cases. We didn't have the advantage then of having the executive office behind us, of having any of the state governments behind us, of having the federal government behind us in the case. That's a big difference in the same-sex marriage cases now.
Phil has already said to me once privately that he doesn't think the case that he took up reflected any special expertise on the part of the lawyers, any extraordinary labor on their part, that the case had come before the Supreme Court when the time was ripe. I have to say, and I told him this, that he's being exceptionally modest. Here you have two young lawyers who take up a case that will and continue to resound through the constitutional law of the land. I think about those moments when he's writing on a yellow pad on an airplane, just basically, frankly, making it up as he goes along, and creates this extraordinary moment in American constitutional history. So I'm very honored to be sitting next to him and to be here tonight. I will briefly say about the episode that I was involved in, and again, I want to be very clear, I always am. I'm speaking entirely for myself here. I'm not in the government anymore. And I'm reflecting on I'm back in private practice, and I'm reflecting on my experience in the DOMA Defense of Marriage Act matter with a little bit of the benefit of distance, but not a whole lot of distance. It's only been a few years. But there, and I'm going to tee off of what Phil said a second ago about where you stand with institutions in a fight over equal rights, where people line up, how the courts behave, how governors behave, how the executive branch, the federal executive branch behaves, sort of what positions they take, what they communicate about how they picture the American Constitution and the fulfillment of the promise in the Constitution of equal rights for all Americans. And as many of you know, in the Defense of Marriage Act cases, Windsor versus United States, there came a moment when the President of the United States, our current President Obama, took the position that he was not going to defend the statute. He has an obligation under the Constitution to faithfully enforce the law, faithfully execute the law, and he stated, the Attorney General reported to the Congress that the administration would continue to enforce the law, but that in court, the administration would not defend the law, and that a separate representation would have to be organized for the statute. This executive would not stand behind it. This drew, a significant amount of criticism. It is a rare thing. The President of the United States, precisely because of the constitutional command and the expectation that in instances where he will reach his own constitutional judgment, he will by and large do so in fairly limited circumstances where I think it's fair to say the constitutional doctrine is settled. There are many people who believe the president can take this position, but only where he's taking this position with an enormous amount of wind at his back. Courts have decided the matter, so even if the statute's on the books, I'm not going to enforce a law that the courts have clearly deemed one form or another, more or less directly, is unconstitutional. That hadn't happened with the Defense of Marriage Act. I think it's fair to say if you look at the litigation that led up around these issues up to the Supreme Court's decision in U.S. versus Windsor, there were indications about where the constitutional law was headed on these issues, for sure. But there was no clear-cut authority, a case that, or a line of authority that was so consistent and so strong on the critical issue here, or the critical constitutional issue, that any president or every president in similar circumstances would have decided to abandon the defense of the statute. I will say that obviously as the great admirer of our current president, he decided he wouldn't defend the statute after consultation with the Attorney General of the United States. And there were a set of circumstances I want to briefly delineate that the Attorney General brought to the attention of the Congress that explained, I think, effectively why the president took the position that he did, notwithstanding the view that this was a rare exercise of presidential authority that he did not exercise precisely as people thought he should in the limited circumstances they thought typically it should be exercised in. Up to the point that the president made the decision, the United States government had defended this statute, Defense of Marriage Act, which, as you recall, was a federal definition of marriage as being solely a union between a man and a woman, and it governed federal benefits and the application of federal law. Up to that time, it had been defended on a under relaxed scrutiny, rational basis scrutiny. And that permitted an awful lot of speculation about what might be proffered in defense of the statute. When I say relaxed standard, it's a very relaxed standard. And then litigation began to shift to circuits where this question of what standard applied, what standard of scrutiny applied, hadn't been settled. And the administration had to decide whether or not it was going to tell the court that it was sufficient to defend the statute under rational basis scrutiny, or whether statutes like this that discriminated in the way that this statute did had to be defended under a much more exacting standard, heightened scrutiny. And the administration took the position that, faced with this choice and knowing it would have to tell the court what position it was going to take on that issue, it was going to take the position, A, that heightened scrutiny applied. This was a discriminatory statute that had to be evaluated under a much stricter constitutional standard. And B, under that standard, this administration, this president, this executive branch was unprepared to say that DOMA satisfied the constitutional test. And because it was unprepared to say that, it couldn't defend the statute. And it didn't. As you all know how it ended up. The case went to the United States Supreme Court. The U.S. Supreme Court divided very sharply on the question of whether or not the case was actually properly before it, precisely because the United States was being sued, and yet the United States, the executive branch, actually agreed with the plaintiffs. So the question was, in what way was this case properly brought before the court? Well, I won't bore you with the doctrinal ins and outs on this. I'm sure they're familiar to many of you who either have studied the case or are law students and are familiar with the case. But one way or the other, in the end, in an opinion authored by Justice Kennedy, it was concluded that the court could, in the exercise of its prudential discretion, decide the case. And the court made the constitutional decision that the president himself, in the exercise of his responsibility to construe, again, in these limited circumstances, in these very defined circumstances, made the same decision that he did, which was that as a matter of constitutional law, DOMA could not stand. So what I would say, is this, as I look back on it: the enforcement, the dawning of a recognition that we are not fulfilling the fundamental guarantees of the Constitution. The dawning of that recognition comes about through the labor in our society, in our culture, in our legal system, of very many different actors. And oftentimes, it comes up from the ground. It comes right up from the grassroots. And it's our elected leadership, over time, after great struggle, that has to be brought to the defense of these rights, to the recognition of these rights, much less their enforcement. And so in the Loving case, you have this couple looking for legal counsel, and in that letter to Bernie Cohn asking not to be forgotten as clients, and who were fortunate to have drawn these two exceptional young lawyers who took their case to the Supreme Court and won it, with, as Phil has said, an officialdom that, if not hostile, when not hostile, stood to the sidelines. And so you have this activism at the grassroots level. You have the parties to the case, you have the lawyers who are there to assist them, and then you have the court stepping in and finally making the decision. And the same thing is true in the struggle for gay rights in the United States. It has come from many quarters over a very long period of time, from the ground up, as well as from the top, from time to time. Support has been provided through the Congress and through the actions of our elected leadership. We have to recognize it comes in all these particular case, and this is the good fortune, I think, that E.D. Windsor had. The President of the United States, with all of the power and moral authority of that office, stood by the proposition that there was an argument that could not be made about our Constitution, and he would not make it. And I obviously am very proud to have been present when that decision was made and to have had an opportunity to participate in the discussions leading to the decision that he and the Attorney General, in consultation with each other, concluded this administration had to make.
We take some questions.
Just very briefly, could you just reshare for everybody who don't know who Windsor is?
Oh, I'm sorry. This was a challenge to the Domestic Marriage Act by a same-sex couple. They were lawfully married. Their marriage was lawfully recognized by the state of New York. And then they discovered that they were subject to, relative to what a heterosexual married couple would have expected, discriminatory application of estate laws when one of the parties to the marriage passed away. And E.D. Windsor is a survivor, correct. Thank you.
Yeah, sure, go ahead.
The challenge, the couple in the Loving incident was arrested in 1958, but they didn't challenge the law until 1963, is that correct?
Well, they didn't go and seek out legal counsel till '63. Yeah, they didn't know there was anything they could do. And when they saw what was going on around them with the March on Washington and the publicity of President Kennedy announced the Equal Accommodations Bill would be put into Congress, they then, one of our friends, you'll see it in the film, one of the friends said to Mildred, maybe you should write Bobby Kennedy, the Attorney General, then, and maybe they can get some help. The ability to challenge laws very often is impeded by the ignorance of people, and I don't mean ignorance in a bad way, but the lack of knowledge people have of the availability of resources to do it. Interesting enough, if Mildred and Richard had done it properly, they'd have gone down the road to Richmond and sought out Sam Tucker's firm, Hill, Tucker, and Marsh, which was a civil rights firm that had the Prince Edward case in the Brown v. Board of Education case. Spotswood Robinson, a very, very renowned judge, came out of that law firm, and they had the legal defense fund behind them, which was much more capable of handling this case than Bernie Cohen and Phil Hirschkopf were at the time. So, but all's well that ends well, I guess. Anyone else? Yes, sir.
To which extent did you, working with the president and the group, look to what was going on in Europe at the time to try to compare, well, where are we on matters like this and where are they? Are there things, trends that we see from Europe that we may consider implementing here? I don't know what happened at the time, but was that a view that you tried to pursue at all?
No, I honestly, I know that, by the way, that is an ongoing discussion of the extent to which we look in the evolution of our own conception of human rights, the extent to which we look to how other legal systems are treating comparable issues. And there's a big debate, for example, about how that analysis is viewed and how it is received when it is on display in Supreme Court jurisprudence. I will tell you from my experience, I can't speak to what everybody involved in the decision might have been thinking, but we viewed this squarely within what we believed was the most appropriate reading of the United States Constitution under the heightened scrutiny standard. We thought that if you look at the tests that have been used to determine whether equal protection has been violated in these circumstances, essentially there are 4 parts to that test for all practical purposes, and that was set out by the Attorney General in his letter to the Congress. The judgment there was squarely looking at the American legal framework. This was no longer a defensible statute. It would not be a defensible statute under the heightened scrutiny standard that we knew we would have to address in the new jurisdictions where the cases were being brought.
How comparable do you think it is what's going on in Virginia now, where the Attorney General says he's not going to participate in an appeal?
Well, I think that this is the interesting question of at what point in these movements and how are they different from one another in the galvanization not just of public and grassroots support, and obviously public opinion has been changing extraordinarily rapidly on the gay rights issue, and it has really pushed public elected officials in a certain direction, in the direction of a much stronger engagement with these rights. And so we're seeing a lot more sensitivity on the part of elected officials than in your era, obviously, you saw, certainly in the state of Virginia and elsewhere, correct?
One of the things you see tonight is, while our president, who I'm a big fan of, gets the credit for what happened in the DOMA case, he had an excellent general counsel behind advising him. He's not allowed to talk, I guess, about what happened internally as to who said what, but somehow, someday, that story will come out of this.
Well, unfortunately, in a memoir-writing town, lawyers are shackled by the attorney-client privilege. So I'm afraid I'll have to keep most of that to myself.
Turn it back to you guys. Wait, thank you. Are you living in Virginia? Because I was on a panel with the head of the NAACP, and he was living in Maryland. It was his folks, I think, had to leave Maryland to go get married, but he didn't realize that Maryland repealed their statute just before we argued in the U.S. Supreme Court. There's only 16 states. But the net bottom line is, living in Virginia now, you have a Supreme Court justice who's in a mixed marriage, and the ex-chief of staff of the Army and Secretary of State is in a mixed marriage, and the ex-secretary of Defense in a mixed marriage, and the head of the legal defense, the Children's Legal Defense Fund is in a mixed marriage. And we just accept it, and that's what's going to happen with gay marriages, with same-sex marriages. It's amazing it's taken this long, because there's more background to accept it from. When Loving was argued, there was nothing discernible that you could see on the public screen and the TV. There was no TV then, but in the movies, where it was an acceptable thing made public. On the other hand, gay rights now, I mean, you had Ellen DeGeneres and people who Rock Hudson, people who we've looked up to and we just accept now. So why we go this extra step and the idiotic arguments that are being made, and that's the real similarity between the whole Loving Jenner and these cases, is the arguments are so contrived. How it'll affect the children. The big argument is procreation, that we must keep heterosexual marriages to keep procreation going forward. But there's no ban on people who can't have children getting married. And there's no ban on children somehow not being recognized who are not born into a heterosexual marriage. The arguments are so contrived. They're religious arguments. They're people who just don't want people any different than they are, but that's the exact similarity to Loving. So.
And that is precisely the reason, those were the kinds of arguments that the president was not prepared to have his administration make. And the arguments that had been made and that were much more available to litigants under that more relaxed standard of review. And it was just inconceivable. I don't want to speak for the president here, but I think those were arguments he clearly was not prepared to make. That was not what the administration stood for, and that was not, and we all know he's a former constitutional law professor, that was not the constitutional vision that he had.
The difficult question you run into is the law has always recognized that the question of what are the parameters of being able to be married in any given state is purely a question of state law. So the states can say, we'll set the marriage age at 17, or we'll set the marriage age at 19, or we'll say you have to have 3 days wait after you've signed it, or you have to have certain blood tests or not certain blood tests. And that's the major argument. It was a major argument made against us in Loving. It's a major argument made in these cases now. And it's a difficult one because it is uniquely a state question. On the other hand, when it's a state question that flies in the face of the United States Constitution, then the Supremacy Clause takes over. Thank you.
Thank you very much.
Thank you very much. Thank you, Bob. And thank you, Phil. I'm Courtney Chapin. I am the Chief of Staff at the National Endowment for the Humanities. And so thank you all for coming and welcome. It was a great conversation, and we're very proud to work with our friends at NYU here to sponsor events like this. So for those of you who don't know what the NEH is, we're a grant-making agency of the federal government. We fund projects that span from documentary filmmaking to radio, television, film preservation, museum exhibition projects that document and preserve endangered languages of Native Americans, and much, much more. We provided the funding for The Loving Story back in 2011, and I'll give you a little bit of the backstory of that grant as a way of introduction. The film actually came into being somewhat serendipitously. Nancy Bursky, who is the filmmaker, was going about her day-to-day life on the Upper West Side of New York City, and she heard about this footage that had been shot in the weeks and months leading up to the Loving's trial by Life magazine. And I guess the intention was that they were going to do something with it, make a film or something, but that film had never been made. And so she sort of snooped around and tried to find out the name of the person who had shot that footage, and then she Googled that name and found that that person lived a few blocks away from her, or someone by that name, on the Upper West Side, and she called that person, cold called them, and she said, "Hello, are you the person who filmed all the footage of the Lovings?" And the person said, "Yes." And she said, "Well, do you still have it?" And the woman said, "Well, I don't know, but I could look for it." And she said, "Will you do that, please?" So an hour later, the phone rang, and the woman had all these reels in her closet. And so that was the beginning of this project, which, along with the incredible gray violet cachet of still photographs, comprise the images that make up the film you're about to see. And it's an example of how important the National Endowment for the Humanities is, really, because you may wonder why a federal agency funding this. HBO distributed it, and I think they gave them some funding too, but it's because this film is we consider it to be a national treasure. This is a film that is about one moment in time, one marriage, one family, one relationship, and all the melee around it. And it's also about Phil Hirschkopf, and it's about this pivotal shift in our nation. So it's an incredibly compelling film, and we're excited that you're all here to watch it tonight. But, the other thing that makes this film so compelling, as you'll see, is that Mildred and Richard Loving are unremarkable in many respects. They were very brave and determined, but these are not people who set out to be heroes. They're not activists. They just loved each other. This is a film that really challenges us and forces us to think beyond our stereotypes. And I know I speak for NYU when I say that we at NEH want those of you who are law students or engaged in the law, the stewards of law, and justice in America for the next 5 or 6 decades, which some of you I know are, to always think about the study of law as the study of history, and to always keep in mind that these seismic moments in our history are really made up of quiet individuals who have the same kind of hopes and fears that we do, and do brave things out of both personal and sort of courageous inspiration. So I hope you enjoy the film. We'll give you the Loving story in just a second.